Is currently the mayor of Occoquan.
Thank you.
Yeah? Yeah.
One person clapped there, Martha. You get that?
All right.
You got that on tape, right?
I was
One
going
person
to.
clapped. Thank you.
I was going to keep on talking, but let's take care of the clapping. Okay? Our moderators are always good sports in doing this. He's been mayor of the town of Occoquan since 2006. And I learned a lot from these biographies, and I may tell you more while we have our 5-minute break, because he's got quite a student resume here. From Georgetown University of the School of Foreign Science. Service, I'm sorry. He earned a certificate in Arab Studies. He also holds a law degree from Georgetown University Law Center. He also has a Master of Arts degree in history from George Mason University. And today, he is a PhD candidate in history at Georgetown University. So besides being mayor, you find time for all this. That's quite remarkable. He's also connected with a lot of the groups, citizen groups in the Occoquan area, and I'm going to expand on this during our 5 minutes. So right now, let's welcome Ernie Porta, who will moderate this and introduce us to all the speakers tonight. Ernie, thank you. Let me get my computer out of the way.
Thank you, Martha, and thank you for having me, Committee of 100 members, and thank you all for attending. We did get a little bit of an introduction to our topic on transparency in government tonight, at least some of us did, because we all got to see Sharon Pandak's hard drive while that was being played around with up there on the screen. So she's setting an excellent example here for transparency in government. We have 4 panelists tonight, and I think what I'm going to do is, since we are running a little bit behind, I'll try to move along very quickly here with the opening remarks. Each of the panelists is going to have 12 minutes to speak. And panelists, there is a timekeeper here who is going to give you signs while you're speaking. One that says half your time is gone, another that says 2 minutes left, one that says 1 minute left, 20 seconds, and a stop or he gives you the hook sign. Okay? For the folks out in the audience, what we're going to do is we're going to hold all the questions, as we typically do, until the end. So we're going to let all our speakers speak first. And then I will come back up to the podium and I will entertain questions, which I'll ask you to very specifically direct if you can. And we'll go through the rules for those when we get to the questions. Our first panelist tonight is Sharon Pandak. And all of you, I think, should have in your program somewhere bios of the speakers, with the exception of one who I will speak about at the end. But let me briefly say a few words about Sharon. Sharon has worked for 25 years in Prince William County government and is currently an attorney who provides advice to localities and presents seminars on Conflict of Interest Act issues, and has worked with the General Assembly Subcommittee on revisions to the Act. During part of those 25 years in Prince William County government, Sharon served as a Prince William County attorney for 15 years, I believe. Correct, Sharon?
Yes. Okay.
All right, so without further ado, let's please welcome Sharon Pandak.
I am being very trusting. I'm leaving my black book of the law sitting between Peter and Ernie. If you figure out the tabs, then you really know my life. I appreciate seeing you all again. I think I've been and talked to you a couple of times before on various subjects, and it's just really a delight to see some faces I haven't seen in a while since I've been out and about the Commonwealth. I want to tell you about the Conflict of Interest Act, and the reason why I brought the black book. Can you demonstrate my black book? If you cannot sleep at night, I recommend you read the Virginia Conflicts of Interest Act. It will definitely put you to sleep. If you're an elected official or certain appointed officials, you better read it, and you better drink a lot of caffeine. But I'm going to give you the nutshell version, and then I'm going to take you through a version that we have done. Most recently, I did it with Angela Lemon-Horan, who's the county attorney, to the VACO supervisors about 12 months ago. But the bottom line version of the Conflicts Act is don't take a bribe. If you have a conflict, disclose it. Now, if you remember those two things, then it tells you a lot about the Act. The Act is not a code of ethics. That doesn't necessarily tell you ethically right from wrong, policy right from wrong, fairness right from wrong. It's a code of laws set forth by the Virginia General Assembly, and we're going to talk about it, and let me see if I can manage this. This could be a real challenge. With some slides, and I think we can do this. And Jim, I'm going to go really fast. So if you all will hang on with me, usually I take questions while I go, but I think we'll take them at the end. Well, we'll see if it works. Okay. There, I got it. That's me. That's my law firm, Griantes, Pandyke, and Stoner. My partners and everybody in our firm has worked for local government, and we largely serve local governments, although today I came down from the Council of Governments in D.C., where I'm general counsel. Okay, Conflicts of Interest Act. Give you the code site. Ernie's got the book if you want to look at it. If you violate it, you violate it at your peril. At your peril, if you're covered and you violate it. Now, I start off to elected officials and I say, well, you were elected. You thought that was hard. You had to fill out a disclosure form. That was really good. It's good practice if you win because you have to do it annually. You took the oath of office. You swore that you would do it right. And this disclosure form you have to file every year has to be signed under oath, notarized, that is. So, every year, January 15th. Now, a common misconception of many elected officials that I have represented over time is that the clerk to the board is their mother. And therefore, the clerk to the board who hands you the forms, and Maria will laugh because she knows this, advising state and local governments, they will say, well, Mom never gave me the form. No, the clerk to the board, Phil Campbell, dear guy, he'll remind you and he'll remind you and he'll remind you, but it's the responsibility of those who are covered by the act to do it. The linchpin of Conflicts of Interest Act is the personal interests of an official or an employee. Now, that's not a term that you look up in Webster's or you look up in dictionary on the internet. Thank you, Brianna. It's a term that's defined by statute, and it includes the following. If you go to the statute, you will read and read and read, so I've tried to digest it. It includes the interest of the officer or the employee that's covered by the act, that person's spouse, whether or not in the same household. And yes, some of my clients ask me if it matters if you have somebody else beside your spouse. And that depends. But definitely spouse, whether or not same household. Dependents living in the same household when they are more than 50% financially supported by the person who has to report. What do you have to disclose annually? You have several forms, multiple forms. Those of you who look at it, you go through there and you think, oh my gosh, this is worse than filling out my income tax. And it goes through there and you have to define the personal interests of those of you and your immediate family. And you have to, it goes to ownership in tangible or real personal property, business and financial interests, paid directorships, salaries. The linchpin here is more than $10,000 a year in value, or more than 3% interest in a business. Additional examples that you have to report if you're an elected official or you're one of the covered officials for purposes of annual disclosure are payments that are made for representation that are in excess of $1,000. Second is payment from businesses that operate in the state of Virginia. Additional examples could be payments for talks, meetings, publications of more than $200 apiece. So pretty thorough in terms of the types of things that have to be listed. Other things, gifts, that is, those things for which you have not rendered services. So if they are from a true family member, friend, whatever, don't have to report them, but if they are those other types of gifts, then more than $50 in value per gift and a combination of more than $100 in value per gift need to be on the forms. You can exclude business entertainment, as I said, relatives, friends, and campaign contributions. Why can you exclude that? You can exclude it because you have to file that on a different form. I told you at the beginning, I want to tell you again, main principle of the Conflicts of Interest Act is you do not take bribes. Sounds pretty easy, pretty clean. But you also don't use your influence for financial gain. So in addition to the disclosures that have to be made, there is a list of things that you shall not do. It's like the Ten Commandments, but it's more than that. One of which is not to participate in contracts that you can't participate in, and there's a lot of delineation in that regard. So what do you do if you have a personal interest? Does that mean you violated the act? The answer is no. You have to disclose it before acting, depending upon the circumstances. So when you disclose, if your personal interest is the only interest in whatever transaction that is coming before you as an official, you will have to disqualify yourself. So you disclose and disqualify. And over the years, I developed forms that allow one to readily do that. However, if you have these other interests that I told you about that are for annual reporting, on specific transactions, you also have to determine whether or not to disclose, even if you've already disclosed it in your annual statement. So that's why you need these additional forms that I talked to you about that we've developed over time. And that's the more than $10,000 in compensation or income, more than 3% interest in a business, and then ownership of real or personal property. Personal liability, so it's not just if you're making money. If you're losing money, big time as defined by the Act, then you have to indicate that as well. And then if you have an option in land, and Martha will remember this because this provision was actually added after we worked with the local government attorneys and on amendments to the Act, and it came out of a situation arising some time ago up in the Gainesville area. And the Board of Supervisors asked for that to be added. Okay, now, remember, it is not just the official. It's any other person in the same household for whom more than half of the financial support is provided by the official, or the official provides, that person provides more than half of their financial support. So, what do you have to do? If you've got a personal interest, you either disclose or you disqualify. And in both cases, you must do so publicly, you must do so in writing. So, what if your personal interest is the same as a group of other people? And different types of groups are shown there. Well, it depends. What do? The groups are defined by the Act as well. And it depends on the number of people in the group, it depends on the type of transaction, it depends on whether, in the example of an ordinance, whether it affects the whole county or whether a specific transaction, maybe a rezoning, only affects a small area and how many people are involved. So, once you read the Act, presuming you've stayed awake, and once you've looked at the issue that causes you to get that nervous little feeling that maybe you've got a connection there, and I really define it that way when I advise my clients. If you get that nervous little feeling, then you are in doubt. And when you are in doubt, what do? You don't ask your spouse. You call. And who do you call? You call your county attorney, or you call your Commonwealth's attorney. Now, or you have your county attorney call your Commonwealth's attorney. And the reason why I say that, and you laugh, there is a big, good reason. Sometimes you call your county attorney first because your county attorney is authorized to give you an opinion. And if you rely on that opinion, you've told your county attorney the right facts, and you happen to be charged later with a violation of the Act in court, then you can say, I relied on this opinion and here it is. Or you can bring your county attorney in to testify, which is not really cool, but you could do that. So, you got a way you can bring in your witness that says, I did this. But if you call your Commonwealth's attorney and you tell your Commonwealth's attorney all of the facts, and the Commonwealth's attorney renders an opinion, then you never get charged, which is a whole lot better than waiting for the court date to bring in your county attorney arm in arm with you. So, sometimes the situations that are raised as conflicts are ones that are genuinely sensitive issues. They are not ones in which it sort of is a blast out there. There are all sorts of nuances that may make people think that they want to maybe be a little careful. I mean, I had one where somebody had a percentage interest in a will, and the person hadn't died, but they knew the will was going to give them this interest, and they wanted to sort that out, but they didn't want it sorted out on the dais of the Board of Supervisors. And they didn't want to send it to the Commonwealth's attorney, because if the Commonwealth's attorney writes an opinion, it's public. It can be obtained. Keith, you can call him up, your eye, and say, I want a copy of that opinion under the FOIA. And unless there's some very, very special reason, you get it. So one of the ways I do is I say, okay, I'm your county attorney, and you should let me know what it is. We'll talk about it. We'll see if we think there's a problem. If it really looks like it's one that's a thorny issue we need to sort out, you need to have a definite answer. Some of them are really clear. Then I'll draft an opinion. I'll go talk to the Commonwealth's attorney, and I'll say to the Commonwealth's attorney, here's what we think. What do you think? And that allows for ready sifting out of those situations. And I dare say a whole lot of people have been kept out of trouble because, so you have a conflict. You want to make sure that you dare to ask before it's too late. Because, as I said, you call right, you avoid penalties, you avoid embarrassment, you avoid loss of office. And so I recommend to my clients, you call early, you call often, and we sort it out. And sometimes those things that seem like they're real issues, it's easier to just disclose, life is good, you go on. And I'll use an example because I used to do it all the time, and Erstein's here, and John Jenkins would come up to me all the time, and he'd say, I want to make sure I got that conflict form out there right away to show them and disclose it. And when she was working for the school system all the time, simply roll the conflicts form out and disclosed it. So with that, I close. Remember, call early, call often. If you're an elected official or you're an advisory official, and I'll answer questions later. Thanks, Jim, for not shooting me.
Thank you very much, Sharon. How many of you have visited the post office in Occoquan at any point in your lives? Okay, then you know that in the town of Occoquan, in addition to the normal disclosure forms that Sharon was talking about, one of the ways we disclose conflicts is we tell Eleanor in the post office, and it'll be all over town before you even get home. So, and Jan and Brandon, don't you tell Eleanor, I said, I'll be using Federal Express for the rest of my life if you tell her, so. Okay, our next speaker is Supervisor Pete Canlin. Pete took office as the Gainesville District Supervisor on the Prince William Board of County Supervisors this past January. Pete has spent his career in the business sector, working for several technology companies, both domestic and international. He holds a bachelor's degree in business marketing from Brigham Young University and an MBA from Marymount University. Please join me in welcoming Supervisor Pete Canlin.
Well, thank you very much. I'd like to thank everyone for coming out tonight. I'd like to thank the Committee of 100 for hosting this event. I think this is a very important topic, and I think this is a great venue that we can have this discussion and this conversation. I did want to tell just a brief story, if I could, really quick. And Janelle, you've heard this story, so please don't share the ending to it. John, I think you've heard it too. Last year, I ran for supervisor. I've been supervisor for about 11 months now. Thank you so much. I ran for supervisor, and I have 4 kids, ranging from, at the time, 12 down to 2 years old. And I was gone all the time. I was gone knocking on doors. I was gone attending community events. I was gone doing everything I could to get my message out to the people of the Gainesville district. Well, fortunately, I was elected, and in January, took office. Well, I remember in January coming home one day, and as Frank and Mike can tell you, you don't have much time at home. You come home, you change, and you go out to your meeting. I came home, changed. I was about to walk out the door. My 5-year-old came up to me and said, Dad, where are you going? I said, well, I'm going to one of my county meetings. He said, Dad, you won the election. You don't have to work anymore. And you know, he didn't quite get that right, but Robin and I sat down a few weeks ago and figured out that I've attended over 300 meetings since being supervisor. Now, a lot of it has to do with I'm the new guy, and different departments want to come in and tell me what they're doing and get my opinion on things. But I have to tell you, it has been my honor and privilege to sit in every one of those 300 meetings. I've absolutely enjoyed it. I have absolutely enjoyed representing the people of the Gainesville District and the people of Prince William County. Now on to a very important topic that we're gathered here to talk about today: openness, transparency, and conflicts of interest in local government. I grew up in Montgomery County, Maryland. It was an interesting experience for me and my family. We were a red house in a sea of blue houses, but it really gave us an opportunity to discuss with our friends and our neighbors the role of government in our lives. Being the second youngest of 10 kids, we would sit around the dinner table and talk about the issues of the day. Needless to say, I grew up with a little skeptical view of politicians. I believe it was incumbent upon them, the politicians, to earn my trust. While I was running for supervisor, I heard many times the concerns people had about all levels of government and the lack of trust they had in politicians to do the right thing. One of my main goals as supervisor has been to restore and enhance the trust the people of Prince William County have with their elected officials. It is, I believe, very critical that citizens are confident in their elected representatives. Without this trust, without this confidence, the whole process of governing becomes much more difficult and muddled. As some of you know, I introduced a motion that would have required members of the board to disclose if they or a member of their family sat on the board of an organization that we were voting to give money to. Ultimately, the foundation for me proposing this transparency motion was to show that this board was dedicated to earning the trust of the citizens of Prince William County. Whether we like it or not, there is a perception that exists in the minds of significant numbers of people in the county that the Board of Supervisors are collectively in the pocket of donors. There are also perceptions of so-called good old boy networks, where favored programs and individuals have an upper hand in receiving taxpayer money. These questions are not unique to Prince William County, but the real concern shouldn't be ignored. In our democracy, there's absolutely nothing improper or wrong about politicians receiving campaign contributions or serving their community on organizations. But it all comes down to the trust in that politician, and public disclosure of contributions and potential conflicts of interest help restore that public trust. This is why I also implemented a transparency initiative for my constituents and all the people of Prince William County. I've committed that I will post on my website before each meeting any contributions that I have received by applicants who have business before the board. In general, I believe people are trusting of politicians if they feel a politician isn't trying to hide something. When I started working on the plan to eliminate the discretionary funds in district offices, an effort that my friend and colleague Supervisor May was a very early supporter of and who was critical in helping me get the necessary support for the resolution, I discovered a real concern by citizens all over Prince William County that certain programs and organizations receive special priority based on relationships between them and the board or members of their family. Whether it's true or not, the perception was still there and still real. To me, the solution comes down to disclosure of those relationships in a timely manner. I know that Supervisor May and I agree completely on that concept, and I believe it is only the method of that disclosure that we have a slight difference of opinion. Mike made the very persuasive point during the discussion of my motion with the board that he personally made repeated disclosures about his relationships with contributors or groups seeking funding, and he believed the intent of my motion was already being met. In short, we simply did not need to duplicate what was already being done. As I can tell you, Mike is one of the most decent, honorable, and ethical people I've worked with in county government. Now, I've only worked in it 11 months, so we'll see. I have had the opportunity to watch him closely in the way he conducts himself in his public life, and I can tell you he is a man of the highest character. I think that is also generally true of the other members of the Board of County Supervisors. My motion on the conflicts of interest was not intended to be punitive to the board in any way, but was designed solely to protect the public. To be clear, my transparency initiative is intended for the benefit of the people, not the convenience of the politicians. It was intended both for today and tomorrow. My conflict of interest motion spoke directly to the preservation of public trust in their elected leaders. There are two specific elements to most conflict of interest policies governing public officials. One, banning conduct by public officials when they use their office to exploit a relationship for personal benefit. Two, avoiding even the appearance of a conflict that would erode the trust from the public. The truth is, most conflict of interests are difficult to define. We think we know it when we see it, but the facts and circumstances in most cases create more questions than answers about whether a law or standard is being violated. In my personal judgment, and the basis for my motion, is that most conflicts fall into that gray area, where ethics and public perception are far more relevant than statutes or precedents. And if we should ever find ourselves in this gray area of disclosure and ethics, I believe that the best policy is full transparency. As the old political saying goes, sunshine is the best disinfectant. With more transparency and greater disclosure by the Board of County Supervisors, we can restore the trust of the people in their elected officials. The issue here is not a matter of accusations or judging the merits of any particular policy proposal. My transparency initiative seeks only to provide sunlight on the local political process to allow the public to make their own fully informed decision. Our constituents have a right to an open and honest government, and we as elected officials have a duty to conduct the work of the people in the most transparent manner possible, above all reproach. A timely and specific disclosure of any potential conflict by a member of the Board of County Supervisors will satisfy this standard because it allows the voters to decide whether an individual board member may be unduly influenced by the relationship he or she may have with an applicant with business in front of the board. I believe that a disclosure of any campaign contributions from an applicant seeking board action the week before any formal vote of that application would also instill a layer of trust in the board's actions. You know, I started this initiative about, I guess it's been a couple months, and before then, when we'd have a person before the board that evening, I'd always get, and if they had contributed to my campaign, I'd always get an email after the board meeting saying, you've been compromised, you've been influenced by this person. That hasn't happened since I've fully disclosed before the meeting that I've had this relationship. People trust politicians, again, if they feel that that politician has nothing to hide. Let me thank all of you again for attending tonight. I truly believe that this is a great step towards restoring the trust in our local government. This meeting where discussion of community opinion leaders on this topic can take place is important because it provides a forum where we can learn from one another, and this discussion will help me to refine my thinking on the issue. Thank you so much for inviting me tonight. Thank you.
Thank you, Supervisor Canlin. Our next speaker is Occoquan District Supervisor Mike May. Mike was first elected Occoquan Supervisor in a special election in January 2007, and then re-elected to a full-year term the following November. Mike is also a practicing attorney at Albo and Oblon. Please join me in welcoming Occoquan District Supervisor Mike May.
Is my thingy gonna work? If it doesn't, we can.
Is it on here?
Yeah. If it shuts back down, I'll just go without it.
Okay.
We don't.
You want me to try to work
I
on
had
it?
this really cool slide presentation, and Ernie screwed it up. So
Oh, yeah.
just kidding. It was like 2 pages. It's a visual crutch, so I'll use my notes. Well, thank you very much, Ernie, for the introduction, and thank you for the opportunity to be with you today. And welcome to the Occoquan District. I appreciate the Committee of 100 having your events out here. I certainly prefer this to Vander Lane. No offense to my friends from the West. But obviously, I want to welcome those of you that came from Western Prince William County. I was talking to some of you, and I appreciate you coming all the way out here. This is an important topic. It's an interesting topic. And I think Mr. Canlin set up the discussion very well. And as he stated, and thank you for the kind words as well. I do appreciate that. I think he and I see eye to eye on a lot of a lot of issues, and I think we both believe that being in any level of government, I think, and I'm looking at Frank, I know that Frank believes this as well, it's a public trust. The citizens have placed their trust in us, and it's our responsibility and our charge to execute our jobs to the fullest extent possible, and with ethics and integrity foremost in our mind. And I do think that the folks on the Board of Supervisors do that. What I wanted to do to set up, and I certainly look forward to the questions because I think that's when we really get into the neat back and forth and dialogue and such. I want to tell you a little bit about some of the things that we as individuals, or at least in my office, we try to do to promote transparency and openness. And then I want to tell you about some of the things that we've done at the board level to promote transparency and openness as well. There's always more we can do, but we have made some progress, and I certainly look forward to hearing from the community as to other ways we can accomplish those goals. With respect to my own office, we have what I like to call, and the reason I think this is important, what we're doing individually, is because that's what we can do as individual supervisors. We can set the example and show openness and transparency. Peter gave some examples of some of the things that he's done. These are some of the things that we've done in our office. First of all, we like to have an open door policy in the Occoquan District Supervisor's office. And what that means is anybody who wants to meet with me will get a meeting with me. I respond to all my own emails personally. We host regular town hall meetings where folks can come out, ask any question, bring up any concern that they want, and we do it in a public forum. And I think that's similar to this. It gives people an opportunity to share points of view and approach me directly, as opposed to trying to route everything through staff and the like. Those of you that are on my e-update list know we send out information at least once a month or more often as to what's going on in Prince William County. And these are not political updates about my political positions. This is just to keep people abreast of what's going on in Prince William County, so you might not know there's a land use matter coming up, or a public meeting on the strategic plan or something like that. We really try our best to keep people informed, and I think that's an important part of openness and transparency. Pete referenced the situation with so-called discretionary funds and what people were using them for. In the Occoquan district, essentially what we were spending our additional funds on, what we continue to spend our additional funds are community newsletters to get information out to the community as to what's going on in the district. I think that's real important. We have in the Occoquan district a collaborative land use process. And what that means is when there's a proposal coming before the Board of Supervisors in the Occoquan district, rather than just waiting for it to come before the Planning Commission and the board, we take a very proactive stand. We encourage developers to work with citizen groups like the Occoquan Civic Group that's just starting up, Locapelt, and others. We send those proposals out to the community so they can be vetted, so that people can have an opportunity to opine on the process, provide their feedback to the developer, and they provide their feedback to me, so that by the time that proposal gets to the Planning Commission and ultimately to the board, we have a real good indication of how the community feels about it. There's been a lot of give and take. And, frankly, the developer has really been put through his paces in terms of community standards. We think that's a very positive thing and a way to encourage transparency in the land use process. And then finally, we have a collaborative budget process as well. I can see Peter's also doing that as well with an active budget committee. We have one as well in the Occoquan district. And we encourage people to come in and give us their thoughts and feedback. And my budget committee has never been something where it's just people that I know and gather around me. It's been open to the community. We've had different people participate at different points in the year from across the political spectrum, and I think that's informed my judgment and helped me to be a better supervisor. Turning to some of the things that we've done at the board level, and I know Supervisor Canlin expressed some concerns about how he feels about perceptions, and there's probably some truth to that, and we need to continue as leaders in the community to try to dispel those negative perceptions. But there are some things that we have done and that we do that I think promote transparency and openness, and I think they at least bear mentioning. First of all, we sort of take this for granted, but we have televised meetings. That's a great way for people to stay in touch with what's going on in the Board of Supervisors. If you can't watch them on TV, you can watch them online. A few years ago, before I was on the Board of Supervisors, there was a movement to try to put Planning Commission meetings on television, which I supported, and I continue to support this to this day. We've never been able to find the funding to do so, but I think that would be a really important way to improve transparency. We have citizens' time. And again, it's something we probably take for granted, but it's not a requirement under the Virginia Code to have citizens' time. It's something we have in our rules of procedure. We give every citizen 3 minutes to come and speak his or her piece. There have been moves over the years to try to limit citizens' time or even, make it shorter or get rid of it altogether. Never supported those, and I don't support those to this day. I think that citizens need to be given the opportunity to speak to their government. We try to get as much information as possible online, and we've been continuing to improve those capabilities. This year, we're working to make the budget process more transparent by working on the process earlier. And if you guys have been following that process, you know that the county staff did an exhaustive exercise in identifying all the things that they're spending money on, what the costs are, what the savings would be if we eliminated them. And it really does create a blueprint, much easier to follow than the traditional budget process for people if they want to design their own budget, if they want to enhance services or if they want to curtail services. And I know that, wow, time is half gone. I know that people on the various budget committees are already starting to use those tools to try to put forward their own proposals. Now, we talked a little bit about disclosure, and one of the things that I wanted to note is in 2010, we actually, by resolution, updated our local disclosure policy. This was before Pete got on the Board of Supervisors, but there were some issues with respect to the Land Use Advisory Committee and some of the people that were sitting on that committee. As a result of that, at the state level, Delegate Marshall tried to pursue legislation to try to encourage all localities to update their local disclosure policies, and he was not successful in that effort. Nevertheless, at the local level, we took it up and updated our local disclosure policy. So those forms that Ms. Pandak was showing at the beginning, not only does the Board of Supervisors and those that are required to do so under the code file those disclosure forms, we also require senior staff to file them, and all members of boards, committees, and commissions to fill them out as well. I think that's another way that we promote transparency, and it was something that was unanimously supported by the Board of Supervisors. And then finally, one of the things, and I have to give Supervisor Canlin credit for this, that we do now is we have economic disclosures, and they're available online. That was one of the aspects of his proposal that was not ultimately successful, but following the conclusion of that discussion, I actually asked without objection that we just direct the clerk to make those available online. They are available online, and if you had seen my thing up there, I would have had an address for you. It's one of those really long ones, but it's right there on the pwcgov.org website. So you can see all of our disclosure forms. You can personally look and see how poor I am, and it'll make you feel really good. No, I'm just kidding. But I really don't have a whole lot to disclose. Someday I hope to have lots and lots to disclose, but I certainly won't use my position to acquire that wealth. Based on the advice of counsel. No, in all seriousness, I think that's an important change. And, those are the kind of things, they're publicly available, and if you want to go down to the McCourt building and you want to ask somebody or you want to file a FOIA request, sure, you can get them. Putting them online and giving everybody access to them is just an easier way to allow people to get involved in the process and find out what's going on. So those are kind of the basics of my presentation, but I really do look forward to the dialogue and the questions and the comments from the community. And once again, thank you for the opportunity to be here, and thank you for the opportunity to serve this community.
Thank you, Supervisor May. Our next speaker was scheduled to be Alan Gernhardt, but as you might have guessed, Alan is not here. Alan has come down with bronchitis, as I understand it. So Ms. Maria J.K. Everett has very, very graciously agreed on short notice to fill in for him. I don't know if you have her bio there, so I'm going to go ahead and read some information about Maria. She's the Executive Director of the Virginia Freedom of Information Advisory Council, a legislative agency created in July of 2000. Since its inception, the FOIA Council has rendered more than 14,000 informal opinions and more than 200 written opinions on the application and/or interpretation of the Freedom of Information Act. Ms. Everett is a senior attorney with the Division of Legislative Services, and she also serves as counsel to the House Committee on General Laws, a position she has held since 1990. She earned a Bachelor's of Science degree from Virginia Tech and a JD degree from the George Mason University School of Law. Please join me in welcoming and thanking Ms. Maria J.K. Everett.
Good evening. I'll probably give less than my 12 minutes, but who knows, just so there will be more time for questions. I agree. A lot of what you've heard already before has sort of stolen my thunder, so I want to sort of take a spin, because with the Freedom of Information Act, it is all about disclosure and of everything government. But I want to talk a little bit about government of, by, and for the people. We hear about public officials and public trust, but I feel a little like Jay Leno when I do FOIA presentations. I ask people, what does government of, by, and for the people mean to you? And I get this reaction, people kind of giggle. And most of them look at their shoes because they don't really know, and they think I'm going to really call on them, and I'm not. But when we really don't know what it means, we embrace it. We think it's a great idea. But when push comes to shove, as citizens, nobody spent any time with what this really means. And so we are the citizens, and we are the government as well. It's for us, by us, we make it up. What a novel concept. I mean, not divinely inspired. You know, kings, I was watching the king's speech last night, and it was like, because I'm the king, divine. It was like, yeah, and your rook does how many, you know. So the idea here of this is about us. The Freedom of Information Act is really the business of the interaction between government and the public that it serves. The Conflict of Interest Act, we have FOIA, we have COIA, you know, we have all these little acronyms going on, is more about once you're in the seat, disclosure, and just of your financial interest. And I just want to read a little bit to you from the policy statement of the Conflicts of Interest Act, because it says the General Assembly, by enacting the statute, wants that it's important that its citizens maintain the highest trust in their public officials and employees. The General Assembly finds and declares that the citizens are entitled to be assured that the judgment of public officers and employees will be guided by law that defines and prohibits inappropriate conflicts and requires disclosure of economic interest. But turning it on its head, it's responsibility of citizenship, because disclosure means zip, nil, nothing if citizens don't look at it. You know, and we do, as citizens, have responsibility. We need to look at these things, because instead of just listening to rumor, to gossip of what's going on in our community. And to tie that in is that a democratic republic is all about responsibility of citizenship. You know, we have to get off the dime and do something as citizens. And I think, you know, I work for the General Assembly. I ask people not to throw things at me for that. But for the longest time, it was like, geez, these guys are crazy. But it's a tough job. And at local officials, and before you even get to the business of governance, you're confronted with laws that tell you about disclosure of your financial interests, laws about retention of your public records, laws about when you have to turn over your public records and how quickly you have to do that, and what form does your response have to take before you even get to thinking about an ordinance. And part of the Freedom of Information Act, it was written in 1968, well before anybody in this room was born. Okay, yeah, okay, we're going for that.
Good disclosure there.
Yeah, right. Very good. But it was tied to a paper world. It was tied to a very different world. And so when I look in the information age, I think to myself, because I live in FOIA land most of the time. I'm switching out of FOIA land into General Assembly land now. But in FOIA land, but what is FOIA and public disclosure and the right of the public to see the records of government? Because we only do it for the public. We're not really doing it for ourselves. But what does that mean in the information age? And I take Mike's point, is going to ask somebody, I want to look at, I want to receive copies of. In the information age, when you're talking to people who grew up never knowing that there wasn't an internet, where they surf, they find their own information telling them you have to go somewhere and ask somebody for something, and then there's a statutory period, they're like, what? This is crazy. So I wonder, just aloud, what true transparency means in the information age. And I think a lot of that means putting things up, already putting it up there. But the perils of just sort of scanning and putting things online raise other sort of issues that nobody ever thinks about. One of them is privacy. And on public officials, you don't really have any privacy, and you already know that. So that's how that got done. But the idea of, with the General Assembly, everybody in this room that owns a house, your assessment records, the deed book and page of your house is a public record. The little footprint drawn, a picture of your house, how much you bought it for, the chain of title, has all been a public record since the dawn of time. But the General Assembly came up with this technology trust fund idea that because business is different, we don't want people going to the courthouse doing searches in the record room. We want these assessment records online. And so when they got online, for a record that has always been open for the mere asking, but the fact that it was visible to anybody who cared to surf there, whether they were in Singapore or Kuala Lumpur. But then you had pushback where it was law enforcement, for example. My dad was in the Secret Service, so I'm not dissing anybody in law enforcement because I know cops. Law enforcement's like, wait a minute, my address is online. There are people that we put away. We did, the bad guys will know where we live. This is terrible. And so there was this act. So technology online, while it's great disclosure, then all of a sudden these privacy concerns come in. And what about teachers? They flunk students. Well, is that another issue? So, disclosure is a great thing. And online is generally works for a newer generation of people. But the idea that, there are certain privacy concerns that we never even thought of when we think about these ideas. Now, as far as the public stage, we have a saying down at the General Assembly for locally elected officials, which is, don't become that which you sought to vanquish. Right? Because you got into local government politics because you were tired of the way things were being done. But somehow, from my perspective as, the person who does the Freedom of Information Act for the state, is that it's thank you for electing me all your hours away from your family. Now, thanks for electing me. Now you all go home and we'll take it from here. No, that's not how it works. And part of what the handouts I brought, they're little fold out. The yellow one is about the Freedom of Information Advisory Council, what we do, our toll-free number. If you have any question about access to public meetings, access to records, you call us. The white one is what we developed for locally elected officials that tells them what their obligations under the Freedom of Information Act are. But public service is a thankless job, especially if you're an elected official. Most of us sit in the audience and criticize, but at the same time we think, thank God, that's them making that tough decision and not me. So it's an interesting balance between you've elected me, go home and we'll take it from here, versus being a lot of people seek public office, not understanding the significant requirement of time and effort away from your home and family, from your work, all those other things. But it's a tough job. It is really a tough job, and it's a thankless job. And people are glad you're willing to do it because, and they'll criticize you. And the only thing I can find that's probably more thankless than being a locally elected official is being a board member on your homeowner association. And so much with disclosure, and I totally agree. One of the things I was going to say is sunshine is still the best disinfectant, and it is. And part of this is we're human. We all make mistakes. But it's like our mom told us, it's never the mistake, it's what you do about it. And so from a Freedom of Information Act point of view, there are records documenting mistakes. There are public meetings that have minutes that document mistakes. It's not that we don't make them. The idea is when you find that you've made a mistake, and tagging into Sharon's remarks, when in doubt, don't. As a public official, you need to stop and be clear who your client is. And your client is the public. Whether you're on a planning commission, you're on the General Assembly, whatever, you work for the the zoning people, or you work for a building official, you mistake that your clients are the people you work with day in and day out. But your clients are the public that you serve. And yeah, and the public can be a little prickly. Okay, that's fine. So can the media. But under the Freedom of Information Act, the constituency of public officials, government, the citizens they serve, and the media that is covered by them, government is the only people that can violate the law. So it's an interesting, and I'm not up here to try to say, wow, poor public officials, because that's not true. I just want that you guys are here, says that you take seriously the responsibility of citizenship. And because this is a two-way street, it isn't for them just to make decisions in a vacuum, it's for you it requires some effort on your part too, to know what's going on, not listen to rumor, because there are disclosure documents out there that you can read and make informed decisions, because that's sort of what the point is if they're not disclosing public or the conflict of interest in a contract, then that's against the law. But then you can read it, and if it still doesn't pass the sniff test, then you vote the next election and do it. So I apologize if I took kind of a strange turn, but I really feel strongly about this business of the public and the government and how it interfaces, is that there is responsibility of citizenship. And I thank you for being here.
Okay, here, for those of you who haven't been here before for Committee of 100 events, I'm going to quickly go through the guidelines for questions. We ask the Committee of 100 members ask questions first, and then guests of those members afterwards. If you have a question, please raise your hand to be recognized. I will recognize you. Once you've been recognized by me, please stand, state your name and your city or magisterial district. And we ask that you please get to your question without a lengthy comment, and if possible, direct it to a specific panel member. If we have time for follow-up questions, we will allow you to ask a follow-up question, but we want to make sure that everybody gets a chance to ask at least one question if they'd like. As the moderator, I am tasked with starting off, so I think I'll start with a very brief question that I'll direct to Supervisor Canlon, and this is just a point of clarification. I'm not sure that everyone in the room actually knows the status of your motion or motions regarding conflicts of interest and disclosure. So if you could just update everyone as to the status so that we're all on the same page. That'd
Okay,
be great.
so thank you. It was a few months ago, I introduced a resolution that would have required the members of the Board of Supervisors to disclose before a vote, to disclose if they or a member of their family sat on the board of an organization that we were about to vote to give funding to. The motion was not seconded, and so did not go to a vote. So as of right now, obviously the motion did not get a second and pass, and so it's pending. Thank you. That's a nice way of saying it's pending.
Okay, thank you, Mr. Canlon. Okay, questions from the audience? I'd like to raise your hand to start off. Ms. Altman, if you could give us your name and your magisterial district, please.
Hi, Brianna Altman, Occoquan District. So my question is either going to be for Maria or Sharon. And here in Prince William County, our Board of County Supervisors, I know other groups that meet, boards that go into closed session. How can we shine sunshine, as you all say, on those types of things? A closed session, for example. I mean, what has to be, what can the public know, and if we can't know it, why not?
Okay, I'll try that one. The idea, when you look at the Freedom of Information Act, this doesn't sound like it's on, though it bumps.
No, it
Okay,
is, yeah.
good. Yeah. Yeah, I know, like ice cream. It's not really the image I had in mind, but it's okay. I like it. It is, it's very clean. I'm sorry. I have 3 brothers, what can I tell you? But the Freedom of Information Act is basically 60 pages long. And of the 60 pages, 40 pages are exemptions to the law. So closed sessions are authorized, just like records are exempt from release. And closed sessions are basically based on a premise that there are times that government needs or should hold things close to the vest because it is still in the public interest, whether it's a bargaining position of the public that they are protecting, a negotiating strategy, a litigating posture, things like that, that are best, the law says, that can be discussed. I know. I didn't.
Check.
Thank you, Mike. Thanks for the ice cream cone, I like it. Chocolate, yeah, I like chocolate. So, closed sessions are allowed under the law. The trouble we have at the FOIA Council with closed sessions is that reporters always say, Prince William County Board of Supervisors went in closed session 37 times last year. Well, as long as it's lawful, number doesn't count. But the idea is, the policy that underpins it is sometimes the public interest is better served, again, protecting bargaining position, negotiating strategy, litigating posture. Let me give you an example. I live in Henrico County. There is a vacant lot next to my house. Let's pretend I own it. I wish I did. If I knew that Henrico County was looking at that vacant lot to purchase for a park or whatever made public purpose, do you think the cost of that lot would just go up because of knowing who's going to buy it? Well, I can guarantee you, if I owned that lot, I'd be high-dollaring. The story in the newspaper would be, you blabbermouth at Henrico County Board of Supervisors, you talked about all these different properties you were looking at, and you had to pay more of the public money than you needed to. So closed sessions under certain circumstances are beneficial, again, protecting the public's position. There are no requirements for minutes to be taken during a closed meeting, but if they are, they may not be required to be released under FOIA, but they are certainly subject to discovery. And so that's why, again, procedurally, to have a closed session, there has to be a statement of purpose, a subject for that closed session, and a code site. Well, the law gives you 2 out of 3 as an elected official. It gives you the code site, and it says purposes for which closed sessions may be held. Purposes: buying or selling real estate, personnel matters, legal advice, litigation, economic development. There's about 41 of them in that list. Subject is what people do not historically state in the motion. And that's what the motion is for the closed session, is to give the notice, we're kicking you out of the room for this general purpose, real estate, but the subject is always forgotten. And they read that whole subdivision of purpose and think they've given you subject. No. And that's the balance, is that you want to tell them why they're being kicked out of the room without giving away the store. So the idea here is, if the subject, let's put it in a school board context, if the subject, it's personnel, it's called the disciplining of a high school principal. Well, in Montgomery County, Virginia, in Southwest Virginia, you would have given away the store because there's only one high school in Montgomery County and you knew what principal that would be. But up here, saying we're going in for personnel for the disciplining of high school principal. How many high schools are there? You haven't given away anything. And so that's what the public trust is the subject a little bit more. And that's the disclosure that needs to be made.
Ernie, can I add 2 things to that? I think that's really helpful, Maria, to lay it out that way. And I'll give you, the additional thing is that when you come out of closed meeting, there has to be a certification that you only talked about those things for which you went into closed meeting and were allowed to discuss. And generally, closed meetings with the groups, the boards that I've represented, both elected and appointed officials, have made those certifications. I do recall a time some years ago that one group had a person who didn't certify, said, nope, I'm not going to certify, and then you have to state that before the vote is made, and that tends to level the rest of the group. It is not the responsibility of the attorney for the group to be sort of the traffic cop to make sure that that happens, but oftentimes that's the case. And I mean, it's not uncommon when I go into a closed meeting to say, okay, if there's any question, here's what we can discuss, here's what we can't discuss. And, you know, I had some colleagues say, well, I threw myself in front of the door and said, you know, it's going open unless you quit this, so I'm not going to do that. But there are ways that you can subtly tell the group, can't go there. And then if they don't listen, then you cut them off. But it's the group's obligation. And I think the things that Maria said about the exemptions are really important, because they are things where the locality can be placed at risk, which is the public fisc ultimately, particularly if you look at litigation. If you're discussing litigation strategy in public, certainly the other side is going to be listening and taking notes. So that's a particularly risky situation. If you're discussing discipline in public, you can't really do that. And you may violate the person's rights in addition to whatever other sensitive issues. Real estate, I mean, pretty obvious things. So I think that it is important for the group to understand, and I know my colleagues and I around the state spend a lot of time talking to our various bodies, saying, here are the rules, here's what you can do, here's what you can't do, and you got to come out and certify. And that certification is real important.
And the last thing I would say is that in the meeting side of the Freedom of Information Act, integrity in government, that's what it's really all about. On the record side is a lot of, you know, getting records, but because you have the ability to have a closed session, again, as Sharon said, it's for limited purposes, you must stay on topic, but the idea is this is the true integrity in government component.
Ms. Everett and Ms. Panda, could you also clarify for the audience on this point, the going into closed session means that the discussion cannot be subject to FOIA, but is there any prohibition on the participants deciding to say whatever they would like to about the closed session outside of closed session? No, correct?
No, the answer
Right.
is no, there's no legal prohibition for squealing on closed meeting. And, you know, and one would say, and I've had members of governing bodies say, we ought to be able to do something to that person who walks out and talks about closed meeting. And the answer is there is no law that prohibits that. There may be huge ramifications, though, for the public body. And in cases of litigation, there may be ramifications for that person as a member of the governing body itself. So I have found that in many cases it is self-correcting after a period of time. Sometimes a longer period of time than one would hope. But again, that's a different matter of trust, because it destroys the coherency of the public body if it's leaked. My view is if somebody thinks that things are being discussed in closed meeting that can't be discussed in closed meeting, then you come out and you say, I cannot certify in a public session, and that's the corrective matter. As much as we might complain, and I might complain even as a lawyer about what the General Assembly does to us at times, there are some checks and balances in there that are not immediately evident.
Another question? Yes, Ms. Ralston. If you could get up and stand up, please, and give your name and your magisterial district.
Hi, my name is Diane Ralston, and I'm in the ASCO. My question is, and as I was listening to supervisors, meetings that are held by committee, you appoint people to committees. These are board meetings. Now, I don't know about Virginia law, but are they subject to the same requirements? We know we offer citizens time. I'd like to know why they're not publicized. I'd like to know why they're not on local government channels. I'd like to know why they aren't part of your mix. Thank you.
Check. There's probably some there's probably some legal answers to that I would defer to the attorneys on from a policy standpoint. As I said before, I would certainly prefer more availability, the better. I mentioned the Planning Commission, for example, and how I supported having those sessions televised. The reason it didn't pass, and it was before both Pete and I were on the board, is a financial issue, because you have to pay the the folks that are filming and producing and everything else like that. And it's not a huge amount of money, but if you haven't budgeted for it, it is something that you've got to figure out how you're going to pay for. As far as are they advertised and stuff, not in the same way that a Board of Supervisors meeting is, but for example, you can find out when the Commission on Aging meets or the Animal Advisory Committee. All that stuff is on the county website, and generally it will say something like they meet the second Tuesday at 7:30 at the Development Services Building or something like that. But they're not, I guess they're not as publicized as our meetings, but so I don't think that's a conscious policy decision on the part of the Board of Supervisors. I think that's probably more a function of not as many people are interested, and I think if you saw more people paying attention and wanting this stuff, you would and sort of a grassroots interest, I think you'd see kind of a response on the part of local lawmakers to try to get that information out. It's just kind of no one's ever asked me that. That's kind of my take. I don't know, Pete.
I would agree with that, and I actually think that having the Planning Commission meetings being viewed on TV is actually a fantastic idea, and I hadn't thought of that. Good job, Supervisor Mann. That's a great idea. But it comes down to, it's a function of cost. It's a function of how many people are going to be watching it. I think that is something that we should review. And if it's been a few years and we haven't had that discussion as a Board of Supervisors, then I think that should be a part of the discussion that we have moving forward. Because I absolutely do believe that as many situations as possible, whether it be financially or people actually watching it, as many situations as possible should be open to the public and should be viewed in a way that that is accessible. I will tell you, just the whole transparency discussion. I remember when I was a kid, my older brother and I grabbed a Hershey bar almost at the same time. The last Hershey bar in the house, we grabbed it at the same time, and he said, "Listen, I'm going to go hide this in the backyard. If you find it, you get to have it." So he went. I thought, I think I was 6 or 7 years. I thought this is a great idea. I'll find it. He went out there for a few minutes, came back, he said, "Go look." I spent about 2 hours looking for that Hershey bar. He had gotten a shovel, and he had buried that Hershey bar 3 feet down, covered it with some leaves. And he said, "Listen, it's in the backyard. I told you it's in the backyard." Technically, he was right. Technically, it was in the backyard. And I think sometimes on local government, we can hide that candy bar. We bury it down there, and technically we are following the law of transparency or the statutes set forth. But I think we need to do a better job of making that type of information available to the public so they don't spend hours upon hours searching for that information.
Just to follow up on what you're saying, because you've made these claims that people aren't being transparent, the whole thing needs to maybe be relooked at. We might even want to address something in the Commonwealth laws as it pertains to committees appointed by supervisors.
Diane, I need to ask you to ask a question, particularly if it's a follow-up.
Can you, Ms. Clinton, come up with some ideas that would help communities who have community members on boards or commissions so that they can get the word out and they're just as transparent as is the Board of Supervisors?
There is a, correct me if I'm wrong, Maria, but there is a legal requirement right now for advisory committees to the Board of Supervisors as a whole have to follow the Freedom of Information Act. And so there are requirements on that with respect to notice. It is not the same requirement it doesn't have to be manifested the same way as a public hearing, for example, where there's a legal requirement that you do a publication once a week for 2 weeks for rezoning or for certain different requirements with respect to budgets. But there is a requirement with respect to publicizing that schedule. Now, for some of those committees and commissions, it's done once a year, and it's not, doesn't have to be in the newspaper. It can be done in other ways. So if you're having specialty type meetings that need to be publicized, given the type of entity that's advisory, then there are legal requirements. The problem with, and I'm not saying that you can't do more, with respect to the Freedom of Information Act, it's a minimum. With respect to the Conflicts of Interest Act, the local governments cannot do things that are different than the act and otherwise allowed by law. So it's a different relationship. But to impose it across the Commonwealth, and I represent on occasion some localities that are quite small and have very small budgets. A legal requirement that you do a certain type of advertising, as in a newspaper, becomes prohibitive for them. So what the Commonwealth has tried to do is come up with a standard that provides certain basic notice on certain critical things, and then there are some other standards of notice.
I think you're right. I think part of the answer is because the Freedom of Information Act was written in 1968. And the idea of notice, because if it's a meeting, there must be 3 things: notice, open to the public, and minutes. The notice requirement to this day under the Freedom of Information Act is notice posted at a prominent public location where notices are regularly posted. That sounds really good, doesn't it? But in Prince William County, where exactly is that? You know, it conjures up, yeah, it conjures up this idea of something posted to a tree or something. We at the FOIA Council are looking at that, because if notice is the point to beat the bushes, to get things out, but all it has to be, and it has to have a physical piece of paper posted somewhere. You can't just put it on the internet or on the website, because then you'd be in violation of FOIA. So we're looking at that issue. But again, back to my original theme, and thank God you asked this question because it ties it in. Responsibility of citizenship. You know, you got to go find it, because that's part of it, because the law is, as Sharon said, is a minimum. You can always do more under the Freedom of Information Act, but we're still in a physical posting mentality.
Oh, I have to gig Keith on this one, absolutely, because one of the reasons why there is not a more flexible requirement for notice that might get out more notice on the internet, most localities have websites, is that the newspapers come in and object to being used as the alternative form to written publicized notice, the ones that are required to be in the newspaper. And so localities go in, they're going to go in again this year and ask for it, and the newspaper associations come in and say, nope, that's a large source of revenue. And
Martha, we have a question over here.
My name is Angela Booker, and I have a question about contracts.
And Angela, what magisterial district are you from, please?
Coles
Coles?
District.
Okay,
Mhm,
thank you.
Coles District. My question is, when a contract is let every couple of years, that contract, say, is won by, in the previous year, it was won, and so the next time that it's advertised, is the response to that original contract open to people who are about to bid the new contract?
Yeah, absolutely. Under the Public Procurement Act, it says that once any contract is awarded for goods, services, construction, once it's awarded, everything becomes public except proprietary information that's been properly earmarked by the vendor that says, this stuff is a trade secret, so this recipe for Coca-Cola you can't disclose. But once the procurement contract, there is an award made, then, and part of that is why that is all open for the asking, is so exactly for the situation that somebody wants to bid on the contract next year, So they want to see what's a relative bid so they can be in the ball game and in the ballpark with that bid. And so, yes, procurement records are all open minus the proprietary stuff.
Mr. Wiggins?
Harry Wiggins, Occoquan. I, from time to time, submit FOIA requests to both the school board as well as the County Board of Supervisors. The school board, I'd say without exception, I get the response within 5 days. The Board of Supervisors, on the other hand, always, every single time, takes the extended period of time to respond. I guess this is to Mike and Pete. Why is that?
I can't speak for the other members of the Board of Supervisors, but I have instructed my staff, and I try to live by myself, that as soon as we get that request, that FOIA request, that we provide the person within the county the information within 24 hours. That's the policy of my office. That's the goal. We don't always get that done, but that is absolutely the goal that we have as the Gainesville Supervisor Office, to get that information to the county attorney's office within 24 hours of receiving it.
Except for, when I get your FOIA requests, I take my time, Harry. I mean, I honestly, we turn them over as quickly as we can. The process essentially is that we, every single supervisor turns it over to the county attorney, and then the county attorney goes through and figures out, what is true. I mean, we basically provide everything, and then they figure out what's FOIA-able and what's not. I mean, I don't want to, I'm just speculating, but it's kind of interesting. We talked a little bit about the FOIA. On the one hand, yeah, it's written for sort of a paper world in the 1960s. The flip side of that is, I mean, you know how many emails now, just everybody emails everything. Everybody sends everything. There's so much voluminous material, and some of these FOIA requests, everything with teacher or pay raise or whatever. I mean, there can just be so much material to go through, so that may be slowing it down, but we should go as quickly as we can.
Yes, Martha, there's a question here.
I'm Kim Simons. I'm from Brentsville District. I actually have a question. I think it's Alan down here on the end. Just point of clarification for something that you said that I didn't quite catch. Notification of meetings cannot just be on the internet, is that correct? So if you have, say, for instance, the school board, which has their little blot where they put these notifications, if there's a notification of a meeting that's put up there that is not sufficient to meet the requirement of meeting notification, is that correct or not?
Notices have to be physically posted.
They have to be physically
somewhere.
posted somewhere in a
Somewhere.
hard copy. So like in a newspaper or
Yeah,
like
it
a
doesn't have
principal's
to be-
newsletter or something along those lines.
Usually at school boards, it's a school board office, but yeah, we're still in a physical posting world. And so you can augment that physical posting by putting it online and doing things like that. But yes, technically FOIA is nothing but a procedural law about how government has to act and do. So, and it says failure to follow any procedure. So the idea that you didn't physically post notice and talking about responsibility of citizens, there's another kind of notice called personal notice that any citizen can once a year write and say, I want notice of every meeting of the Board of Supervisors, any committee, subcommittee, whatever. And then in addition to the physically posted notice, that person requesting that notice gets whatever you work out. They can send you an email, they can send you the notice, they can give you a phone call. But technically, if you don't physically post and you put it on your website, that's a violation of FOIA, which would allow someone to sue for a violation.
In Occoquan, for example, we do physically post in the post office. We really do that on the blackboard there, or a bulletin board. Martha, there's a question behind you.
I thank you. Tom Fitzpatrick, Occoquan District. I'd like to take one quick moment to, it was mentioned McKeith, but I've read your work over the years. Really appreciate it. Real loss to the community that we don't have that ray of sunshine, so appreciate it. Thank you. And in the same context, the need for information, I've been a lifetime bureaucrat. The bureaucrat from hell is the way I've often described. And that's because bureaucracies are so intricate by their nature, sometimes by their design. And by design, I mean by intent. And ironically, the three supervisors who are here tonight are the ones that don't need to be in church as much as some of the others, in my opinion. But isn't that always the way it is? You know, but yes, and my question is there a way that the board can take the initiative for itself, collectively, not individually, collectively, and for the staff, who I feel, as an activist over 25-plus years, feel that are less than forthcoming, to make the information more accessible. And by accessible, I mean exactly not a chocolate bar buried 3 feet in the backyard underneath leaves. That is a great example of what it's like, even for a seasoned, experienced bureaucrat, trying to find information in this place that we live. So what I would like to ask is, can the board, especially the three members here tonight, whom I have respect for, can they take a leadership role within their body and for the entire government, to include staff who will outlive you, most likely, and try to institute open door policy? The initiative years ago of opening up committee meetings and things like that, and putting that on the web or someplace else, that was killed. Frankly, with the technology today, I think that needs to be revisited. And I think it needs a serious, serious look, especially in the absence of the Fourth Estate. So can someone do that?
Let's expand on this question just a little bit to address, I think, an issue that's sort of hanging out there, which is, it seems like there is some general agreement on principles, but as Supervisor Canlin noted, his motion was never seconded for his particular conflict of interest and disclosure suggestion. So I hate to put you on the spot, Supervisor May, but I think in answering this question, it would be good for the audience to hear what is the rationale for that motion not having proceeded and still not proceeding at this point in time.
Well, and I think Mr. Fitzpatrick speaks to a broader concept than just what Pete was referencing. So I guess first to answer that, Tom, I think, yeah, and I think you sort of hit the nail on the head. I think between Frank and Pete and myself, we're going to continue to do everything we can to try to promote transparency at the local level. But it is a challenge, and we need your help. And we need the help of all the folks in this room that feel the same way to get in touch with their own supervisors and continue to push these things on an issue-by-issue basis. Turning to Supervisor Canlin's proposal, make a couple of comments. First of all, I thought his proposal as he drafted it would have been a good way to deal with the discretionary fund issue if we had decided to continue to fund things through the discretionary fund process. What we had done probably a couple weeks before that is reform that process so that you no longer had at the local level what essentially became a local earmark, where you could go the week before and say, I want to give notice of intent to give X amount of dollars to thus and such charity. When supervisors have, the individual authority to direct those funds directly to those entities, I think it would have been appropriate to say, oh, and by the way, I am on this board, or I have I'm particularly interested in this. Once we eliminated that, really the only two times we do appropriations for these entities are during the budget and during carryover process. So as Pete had proposed the proposal originally, he had basically suggested that we would have to recuse ourselves from the vote if you were serving on a not-for-profit. As a practical matter, and I'll disclose, and I've disclosed publicly, and that's another thing that I sort of had a concern with. I'm on the Boys and Girls Club Board of Directors. I've been on the Boys and Girls Club Board of Directors for I don't know how many years, since before I ever got on the Board of Supervisors, and it's one of the reasons that I decided to get involved. Getting involved in the community with organizations like Locapelt, the Conservation Alliance, and the Boys and Girls Club Board. So that was something I was doing long before I came to the Board of Supervisors. to basically say that I had to choose between voting on a budget, which I was elected to do, and continuing to serve on the board of the Boys and Girls Club. That doesn't really, to me, seem to be a fair choice. Now, again, if I'm taking it and I'm specifically earmarking the budget, that's a different story. But these funds, the Boys and Girls Club has always been supported as a community partner since long before I ever got on the board of supervisors, and I suspect after I'm gone, it will continue to be a community partner. So my influence, to that organization, or at least in terms of county funds going there, it just doesn't exist. The second thing I would point out is I don't make any money being on the board of the Boys and Girls Club. And we talked a little bit about the Conflict of Interest Act, and I'm sort of summarizing it here, but it basically relates to pecuniary interest. If you're making money, you need to disclose it. If you're not making any money, it's really just serving the community. Now, I still understand the concern, and so what I said is, I will go ahead and voluntarily disclose that. It's already on my website. It remains on my website. And next year when we vote on the budget, I'm going to let everybody know that I serve on the board of the Boys and Girls Club. I have no problem doing that. The second thing I did, another part of his resolution, which I touched on in my presentation, was the fact that he suggested part of the resolution would actually put the disclosure forms online. And following the fact that his didn't get a second, I said, look, board's not ready to move forward on this, but let's go ahead and put the disclosure forms online. That's an easy thing we can just direct the clerk to do. So even though we didn't pass a resolution per se, we did part of what Pete was pushing for. So between the time he proposed that and he got to the board, he was talking, I think, to Pete, you can probably change correct me on the narrative, but he was talking to different supervisors, getting concerns or whatever, trying to come up with something that everybody could live with. So by the time we got to the actual board, the proposal had changed, and it was no longer you have to recuse yourself from the vote. Instead, it was just you have to disclose. And I think that was for two reasons. One, he was trying to get, again, you can correct me if I don't have the narrative. I think he was trying to get support. And secondly, and I think Ms. Pandak will tell you, I don't think we really have the authority to prevent an individual supervisor from exercising a vote. I think it's a violation of the state law. So again, the question was on disclosure, and what I essentially said was, look, I'll just voluntarily disclose it, but I don't. And then finally, when we were actually looking at the language, and I don't have it in front of me, and I'm sorry, but essentially what it did is it created a local definition of the term conflict of interest. Conflict of interest is a legal term of art that's contained in the Conflict of Interest Act. And maybe the lawyers can speak to this, but when you are trying to establish local policy and you use terms that specifically are the same as the ones at the state level, you can create confusion. A conflict of interest is a conflict of interest because it's defined in the state code. So if you want to then turn around at the local level and define a new conflict of interest, which in my opinion is not a conflict of interest, that can create confusion among citizens, and it can create confusion in moving forward in policy. And the final thing I would say, and I understand where Pete's coming from, and like I said, I think ultimately the practical effect from my perspective is I'm essentially going to do what Pete would have had me do had his motion passed. Number one, we put the things online. Number two, I will go ahead and voluntarily disclose them on the Boys and Girls Club board before the board appropriates any money to them. But I do have a little bit of a concern when we start to talk about regulating the appearance of impropriety. The beauty of the conflict of interest statute is it's a bright line rule, right? It says if you have a pecuniary interest, if you make money, that is a conflict. The minute you start saying, I'm going to regulate the appearance of impropriety, well, then the question becomes, who is the arbiter of what appears to be improper? In my opinion, the arbiter of what is improper are the voters. And they get the opportunity to decide whether or not the supervisor or any other elected official has not acted in the appropriate interest during election time. You look to Congress, the last time they tried to regulate the appearance of impropriety was something called the Campaign Finance Reform Act. And that begat 527s. And then that led to these super PACs. And now something that was supposed to promote transparency, we want to get soft money out of politics, we want to get the appearance of impropriety out of politics, has actually made the situation worse, in my opinion. And so that's something we have to be careful about. And the final thing I want to bring to your attention, again, when we talk about regulating the appearance of impropriety, is some legislation that was in the General Assembly. I want to say it was last year, and I'm going to pick on her because she's here. My planning commissioner, Kim Hosen. Many of you guys know Kim. Kim is the executive director of the Prince William Conservation Alliance. This is an organization that works its tail off to promote conservation issues in Prince William County. Kim has been attacked ever since she's been on the planning commission when she was Supervisor Stewart, now Chairman Stewart's planning commissioner, and she's been my planning commissioner, by people in the development community. And they say she has a conflict of interest. Kim doesn't make any money on any development proposals, but she happens to have a certain point of view, which by and large I agree with, that we should do our best to control growth and that we should do our best to try to make Prince William County a great place for our community by setting aside appropriate open space and preserving our environment. And Kim's been attacked, and that's fine. I mean, I can handle, people having differences of opinion with her politics or with my politics. But they actually filed a bill. They filed a bill in Richmond. You may have seen this, Council. It was House Bill 405, which stated that no member shall be appointed who holds a pecuniary interest or professional position with any organization to which the outcome of local planning and zoning policies is integral to the organization's mission. Didn't mention the word Kim Hosen in it, but I think as we talk to people and people in the community talk to people, this was a targeted bill against Kim because certain people in the development community perceive her as having a conflict of interest. Well, I don't see her as having a conflict of interest in standing up for our community, and I think that bill was wrong. And while I understand what Pete's trying to do, and I'm not trying to say that this is what, you had anything to do with this, but the principle, I think you have to be very careful when you start trying to regulate the appearance of impropriety. I think it's the responsibility of citizens to regulate the appearance of impropriety, and when the Board of Supervisors does something with which you disagree, and you think that we are being improper, you need to let us know. But I just, didn't agree with the specific approach. And obviously, I can't help but say it does sort of affect me personally because I want to choose to serve on a volunteer board for which I receive no compensation whatsoever. And I think, probably some of the other board members felt personally attacked by that. And I don't think that was Pete's intention, but that's just kind of the fact of I think, how they reacted. So that was a long answer, but that's how I feel.
Thank you.
So, okay, yeah, worth applause. So if I got this correct, my conflict of interest resolution is going to lead to more super PACs and also retribution against Ms. Hosen. No, I say that in jest, obviously. I think we missed an opportunity. At the Board of County Supervisors, I think we truly missed an opportunity. If you think about this time of year, we had just come off of the discretionary funds issue. A lot of people had concerns about that discretionary funds well before I got on the Board of County Supervisors. And so I got a real sense out there in the community that people were having issues on trusting the Board of County Supervisors. And I originally kind of took my background in the business community. I sit on different boards and mostly purchasing and things like that at my company and over the years. And I think in the private sector, if we were to give any sort of funding to an outside organization, and I did not disclose that, well, actually I'd have to disqualify myself, but if I didn't disclose that either a spouse of mine or I sat on the board of that organization, whether I was receiving financial gain from that organization or not, I'd be in deep trouble. And so my original motion had said, you can't vote on it. Over time, I realized that some supervisors had some concerns, and I'd already put the motion out there, and I really thought it would be a black eye on the Board of County Supervisors if we did not pass something. So I took a big bucket of water and I watered that down, and I said, okay, you don't have to disclose, just mention it. Or you don't have to recuse yourself, just mention it. Just disclose before the vote that either you or a spouse sit on the board of an organization that we're receiving funding to. I thought it was a simple request. I thought it was something just fundamentally honest that we should be doing. I hope, it is ironic that Frank, Mike, and myself are the ones in this room because we do go to great lengths. And I applaud Supervisor May and Supervisor Principe for the great lengths that they go to disclose information. And this was never about being, as I mentioned earlier, being punitive to anyone. But we create rules not only for today, but also tomorrow. And I felt that this was an opportunity that we had to start building that trust that we had maybe lost a little of during that debate. So my hope is that we can come together again, that Frank, Mike, and myself can work together to try and institute some additional reforms, that we can let people know that we don't have anything to hide, that we all have the best intentions on getting up there, that we volunteer in the community, we serve countless hours. And I know the sacrifice that Mike and Frank make with their family, with their time. I think we can come together and we can put forth some additional conflict of interest and help to restore that trust.
Okay. And I'm sorry, I didn't mean, I just want to add, again, just so everybody knows, I'm going to go ahead and disclose that I'm on the board of the Boys and Girls Club before we take any vote, because Pete, pointed this out and has a concern with it. And I don't think it's an unreasonable request. I don't think we need to amend the actual county rules of procedure to accomplish what he wants to accomplish. And, did anyone not know I was on the board of the Boys and Girls Club before I mentioned this? Okay, Mr. Haddow didn't. And okay, so I guess there's like 3 people here in the room. Check my website, and it's up there, and I'm very proud of my service there.
Mike, you're on the board, right?
Yes, you can quote me on that.
Ms. Pandek, you're going to have the last word here.
Can I just add one thing here? Because I want to make sure that it's real clear, because sometimes we lawyers are a pain in the neck, but if you want to change things, this gets to Maria's view of responsibility. If you want to change things, you have to pick the right forum. And the General Assembly, in its wisdom, I want to disclose I am not a member of the General Assembly, has for many years believed that the Conflicts of Interest Act is to be uniform across the Commonwealth, unless it grants some very specific other additional powers. Fairfax has a specific power where it can ask for more information. Prince William has a revolving door ordinance, which is consistent with the authority that it has from the General Assembly. But if the inherent problem with having a requirement adopted by the Board of Supervisors in Prince William that is stronger than what the state law is that it is not permitted by state law. And Delegate Marshall and I don't always see eye to eye, but we spent a lot of time together when he was gracious enough to undertake not only the issue that I mentioned up in Gainesville about, 15 years ago, but other issues that were cropping up around the state, and put together a subcommittee, and we had testimony and all sorts of things to try to sort out what the right minimum ground rules are, because it was pretty clear that the General Assembly was not going to give all this separate authority. So you have kind of 2 choices if you want to get to the board itself imposing new regulations. Either one, go to the General Assembly and get that specific authority, whether it be for your role with respect to disclosure about family memberships on other bodies where there's no financial involvement, or 2, get the General Assembly to put that into the act so that every local government across Virginia has to have the same rules. And I don't know why they came up with that in the first place. I think part of it was that they said, okay, we're one Commonwealth, and we want to make sure that there is a minimum standard where you go anywhere in Virginia and you don't have to worry that you're like in some other place down on Mississippi, far, far south, that has had lots of problems with corruption. We ain't going to have that in Virginia. Wherever you are, you're going to follow the same rules. And so I say to you, if you are interested in some forms of more transparency related to conflicts, then you need to go to the General Assembly, either specifically or with general authority, in order to make that happen. That doesn't keep us, again, the Conflicts Act does not regulate morality or ethics or anything else. So if one wants to disclose individually or be more transparent, no problem, you can do that.
Okay, that was the last word on this. If we could all, yeah.
Could I just follow up? I hate to
Oh,
take
yes,
this
please.
prerogative, because
You're the president.
this is later than we've ever been here, but since you mentioned it, there was a conflict of interest law that started out being proposed statewide and wound up only applying to Loudoun County, was there not?
That's correct. There is one, and it, again, but it's by the General Assembly that they enacted that specific provision. So, again, it didn't cover the entire state, but the General Assembly had to adopt it in any event.
Right, and it started out statewide and wound up with just that one county.
Okay, if we could give our panelists a round of applause, please.